Good afternoon, everyone. Welcome to this webinar put on by the Global Encryption Coalition. My name is Greg Nojeim. I'm with the Center for Democracy and Technology. We're a Washington, D.C. based organization, and we have a sister organization in Brussels, the Centre for Democracy and Technology. I direct our security and surveillance project, and I sit on the steering committee of the Global Encryption Coalition. The Global Encryption Coalition is the sponsor of today's webinar. It is a 3-year-old organization with about 330 members, and it's steered by 3 organizations: mine, the Center for Democracy and Technology, Global Partners Digital, and the Internet Society. You can find our website at www.globalencryption.org. The Global Encryption Coalition has been pushing back against anti-encryption proposals in areas around the world. Our work includes proposals in Turkey, the EU, India, Brazil, and here in the United Kingdom as well, where we are facing a challenge from the online safety bill. In many of the cases in which governments propose anti-encryption measures, their goals are laudable. And one of the key motivators of some of the anti-encryption proposals is the protection of children against sexual abuse online, which is a goal I think everyone can support, especially advocates that are dedicated to the protection of children. And that's why a report from the Children's Rights International Network and Defend Digital Me caught our attention. The report is called Privacy and Protection, a Children's Rights Approach to Encryption. I'm going to drop a link to the report into the chat. Actually, I think I'm going to be asking Jamal, who is running the show here, to drop that link into the chat, because I'm not sure I can get it to everyone. But let me go ahead and do that right now. And what was interesting about the report was that it's coming from child rights groups focusing on the protection of children. And it included a really thoughtful, balanced look at the contentious debate about encryption. And it looks at that debate through the lens of children's rights and suggests a path forward for lawmakers. That's new, that's interesting, that's groundbreaking, and it's timely as well, given the advance of the online safety bill in Parliament right now. So we thought to bring together the authors of the report and some members of the Global Encryption Coalition who are involved in the debate on the online safety bill. I'm going to introduce them to you briefly and then turn to them for their comments. After each has a chance to speak with me about their concerns, we're going to open the discussion up for your questions and comments. And there are 3 ways to submit your questions and comments. You can email them to questions@cdt.org. You can tweet them to #CDT questions. Or if you're watching this on Zoom, you can put them in the Q&A function at the bottom of your screen. We are on the record, we are recording, we are live streaming at CDT, and the Internet Society is doing it as well. And let's get into our program, and let me introduce you to our speakers. First up will be Diana Gheorghiu, a legal and policy officer of the Child Rights International Network. It's a think tank that's focusing on the rights of children. Her specialty is exploring the intersection of law, technology, business, and human rights. Caroline Wilson Palow is the legal director and general counsel of Privacy International. She leads the legal strategy at PI and it has been working for 33 years to protect democracy, promote dignity, and demand accountability from institutions that breach the public trust. Jen Persson is the director and founder of Defend Digital Me. It focuses on protecting the privacy of children and has a special focus on the surveillance of students and how surveillance can impact those students. June Pang is the Policy and Campaigns Officer at Liberty, and her focus is on protest, policing, surveillance tech, data privacy, migrants' rights, and importantly, the online safety bill. As I said, I'll be engaging each of our speakers for a few minutes, and then we'll open the door to your questions. With that approach, with that brief introduction, maybe a little longer than I had hoped it would be, let's turn to Diana from CRIN, the Children's Rights International Network. And let's talk, Diana, about the paper that you all have issued, you and Defend Digital Me. The paper is called Privacy and Protection, a Children's Rights Approach to Encryption. And it looks at encryption through the lens of the rights of children. When we look through encryption, when we look at encryption through that lens, what do we see that we might otherwise miss?
Hello, everyone. Thank you very much for the invitation to speak about our report and about the children's rights approach to encryption. And thank you very much for your question, Greg. The answer to your question, I suppose, is in the very title of our report, Privacy and Protection. Why do I say this? Because the debate around online regulation in general and encryption in particular has in recent years become very polarized. So we are seeing a divide between, on the one hand, approaches centered on civil liberties, and on the other hand, a child protection focus. And the emphasis in the debate has in some ways become about privacy versus protection, or even more bluntly, the privacy of adults versus the protection of children. But if we take a children's rights approach, meaning if we take all children's rights seriously, we see that this is not a helpful framing. So in our report, we argue that children, their rights, their interests are really on all sides of the discourse, and that the applications of encryption engage nearly all of their human rights from a wide variety of angles. We treat the UN Convention on the Rights of the Child as an agreed international framework that covers the full range of children's rights, from protection from violence to privacy, freedom of expression, access to information. And we systematize our arguments in a list of benefits and risks that the applications of encryption can pose to convention rights. And I think we make three arguments that hopefully convey the complexity of the debate. One, children are fully formed subjects of rights. Privacy is one of those rights. Privacy is, moreover, a key right for children's development because it allows them to shape their personalities to find out who they are. Two, privacy versus protection is a false dilemma. It's simply not the case that encryption poses only benefits for privacy and only risks for the protection of children. So to give you some examples, encrypted channels can be used to circulate, as we know, child sexual abuse material, and this violates the privacy of victims. At the same time, encrypted channels can be used, for example, to communicate safely with the outside world and to seek help when children are victims of violence, even perpetrated by a family member. So this is why it's not privacy versus protection, it's privacy and protection. And actually, even privacy and protection might feel reductive, because in our analysis, we show that encryption engages not only children's right to privacy and protection from violence, but also, among others, non-discrimination, the right to life, freedom of thought, conscience, and religion, the right to health, and even the protection of children affected by armed conflict. So the children's rights approach imposes a framework that hopefully helps to make sense of the complicated disagreements that are in this space. And it also shows how rich and complex the debate really is.
That's really helpful. And I read the report, and one of the things I like about the report is the way it tells stories. It lays out 12 scenarios in which encryption is important to a child because that child is particularly vulnerable. Could you talk about some of those scenarios that you've laid out in the report, and why in some contexts encryption is particularly important for some children?
Thank you. Yes, so I think we included the scenarios because we wanted to open up the discussion beyond this paradigm, privacy versus protection that I mentioned. And as you said, it's by means of examples, it's in an accessible way, and it's really meant to show that the impact of encryption, whether positive or negative, varies significantly depending on children's backgrounds, their needs, their identities. And a children's rights approach to encryption must engage with these issues, must include specific experiences of children from disadvantaged or marginalized communities. And these stories, I think, are also important in order to showcase an aspect that has received less attention in the debate, which is children's agency, their ability to make decisions, to exercise their rights in a whole range of settings in relations to others. So just to give you some examples about these settings and these relationships. So for example, in relation to the state, we discussed the case of children who are politically active under repressive regimes or who might be whistleblowers. So say a child uses platforms to organize a peaceful protest against the government or to blow the whistle on systemic injustice. Now, if the platform is unencrypted, if the government monitors communications and finds out, the government could identify these children. It could subject them to violence. It could even prosecute them. Or in relation to the family, say you have a child from a culturally conservative family that wants to access information to understand their sexuality, to answer questions around health, to communicate with other members of the LGBT plus community. Again, if the communications are not encrypted, if there are parental controls in place such that the parents can find out, this really puts the child in a very difficult position in relation to their family and might even mean that the child is at risk of violence. But of course, it's not a simple case of encryption only posing benefits to children from disadvantaged or marginalized communities. So in relation to platforms, for example, encryption could pose serious risks to children's right to be protected from violence. And here we have an example of children from ethnic minority groups that are being targeted by hate speech through end-to-end encrypted platforms, and this goes undetected. So again, I think the scenarios, like the rest of the report, are meant to show that this is a rich debate with no simple answers.
I got to say, I was very impressed with the report, and I like the way that you worked to achieve balance. You interviewed a lot of different people, including our Europe director and folks involved in protecting children from the law enforcement perspective. Could you talk to us a little bit about kind of walking the tightrope between the different sides of this contentious debate and how you went about putting the report together, given the polarization that exists in this debate?
Sure. So I think the report is really an attempt to provide nuance, to provide a rich discussion. And this is an area where there are so many specialists. There are so many areas involved: child protection, children's rights, privacy, digital rights. And we found it very important to try to really be an open-minded conversation partner. And we carried out the interviews that you mentioned. We carried out consultations, questionnaires with experts. And we also talked, for example, with adult survivors of online child sexual abuse. And it was really about us trying to understand the richness of the arguments, to be this open-minded conversation partner that I mentioned, and to set on paper, and very importantly in people's own words, the areas of agreement and disagreement, in order to try to identify ways to move the debate forward. So one of the chapters of our report really focuses on these frictions and fault lines that exist, but also is really looking at ways where people come together even when it might not be immediately apparent that they can do so.
Really, it really is an impressive piece of work, and we're happy to highlight it, and we thank you for putting it together. I want to turn now to one of your interviewees, Caroline Wilson-Palow. Caroline, obviously you've read the report, but you've also been a leader at Privacy International, which has been a leading advocate for encryption for a very long time. In fact, just a few months ago, PI issued a report securing privacy that focuses on end-to-end encryption. What is it? What are the features of end-to-end encryption, and why are governments trying to break it? And what are the proposals that would do just that?
Thanks, Greg, and thanks for inviting me to be on the panel as well. Yes, as you said, I'm at Privacy International, and for a very long time, we have worked on defending encryption. So we are coming at this from the perspective of one of the privacy organizations that Corinne and Defend Digital Me interviewed. But much like has already been said, we don't see privacy and security or privacy and protection as being mutually exclusive in this context. We see that as being a false dichotomy, and something that we are always fighting for in this very complex and hard debate is trying to find a way to make sure that we preserve privacy and security for everyone, which is why we named the report Securing Privacy. With regard to your question of what was the focus of what is end-to-end encryption, which was the focus of our particular report, it is a particular form of encryption. So encryption being generally the idea that our communications are secured using mathematical algorithms so that only the people who have access to keys, who can unlock that mathematical formula, are able to read the content of the communications that are being sent. End-to-end encryption, which was the focus of our report, is a particular type of encryption that is especially secure because no one but the sender and the recipient of the communication can read the content of that communication. So, for instance, a lot of us use communications mechanisms like WhatsApp or Signal that are end-to-end encrypted, and WhatsApp, for instance, cannot read the content of that message. They have no access to it because it is end-to-end encrypted. It is only accessible to the person who sent the message and the recipient or recipients of that message. End-to-end encryption can also be used not just for messages and communications in that form, but also a lot of other forms of communications that are made over the internet. For instance, sending personal data like health data or financial data, which is a reason that it is a really important tool for, and this is highlighted really well in the Corinne report as well, for a whole variety of purposes, not just messaging individuals. But one of the reasons we are so supportive of it is we think that for individuals, it is particularly important for the development of their dignity and their autonomy and so many other purposes besides just protecting their privacy. So why are governments trying to break end-to-end encryption? Well, it's because of this idea that with end-to-end encryption, the company that is facilitating the communication, in particular, we're talking about messaging, no longer has access to that content of the communication. And right now, in the status quo in a lot of the big technology companies that we use to communicate, they have access to the content of our communications because they're in the middle of them. And so if law enforcement wants to get access to the content of those communications, or as is the case with the debate around child sexual exploitation material, if they want to get access and try to search for that, the companies voluntarily, they can do so because they have access to the content. But with end-to-end encryption, the companies no longer have that access, which means that it is harder for law enforcement to request that or to search, especially in bulk, the content of these communications that are being sent. But it also protects us in a whole variety of ways from potentially abusive governments who want to get access to that content for much less legitimate purposes, from criminals, from the companies themselves who are maybe exploiting the data in the nature of that content, which is why we're a strong supporter of end-to-end encryption. So what have governments been doing to try to work around this increasing deployment of end-to-end encryption, which has been happening especially more and more since Edward Snowden and the revelation that there was a lot of mass surveillance happening at the government level trying to get access to all of these communications. And Some of those proposals that have been on the table for years, and they tend to vary, but include, for instance, since there's this mathematical formula that's used to encrypt the communications, you can have these keys, including potentially a master key to decrypt communications. And so at times governments have sought to have one of these master keys to decrypt all the encrypted communications. Or more recently, there have been proposals where the communication is a message between people or multiple recipients, to have an invisible user that the government could force a company to put into that communication. So then that invisible user could potentially be someone from law enforcement to listen in and get access to the content communication. Or perhaps maybe most relevant to our debate today is a new form of filtering, not looking at the communication while it's in transit, so in the middle, but instead at the communication before it's sent or after it's received on the ends of that end-to-end encrypted communication. And this is called client-side scanning, the client being the device that is sending the message. And there are a whole host of things that can be done there. A lot of the proposals are around sort of having filters to try to detect potentially problematic content that is being sent in that context. We're quite concerned about all of these proposals. All of them fundamentally break the idea of end-to-end encryption, which is to protect the content, the privacy and security of the content of the message. Client-side scanning also has a lot of potentially bad applications because of the potential to go, what type of content could be scanned for, even blocked or censored with the client-side scanning, and it may go far beyond CSAM or abusive child exploitation material. And we've, in our report, done quite a lot of analysis from a legal perspective of how this is neither necessary and proportionate, most of these proposals, because they would affect everyone who is using end-to-end encrypted communications. They are generalized monitoring obligations in some cases that are really quite problematic from a human rights perspective.
Thank you so much, Caroline. And thank you for coming on, even though you have a cold and it's partially robbed you of your voice.
Yes.
I really appreciate it, and we really appreciate it. Let's give Caroline's voice a rest and turn to Jen from Defend Digital Me. DDM was a co-author of the report that Diana described. And Jen, I'd like to I'm sorry. I'd like to turn to relating that report to the online safety bill that's now pending in Parliament. There's a lot in that bill, but could you give us kind of a bird's eye view of the legislation and tell us about how it could impact encryption and the rights of children?
Sure, thank you, Greg. Yes, now that's a huge ask in just a few minutes, but I'll touch on, I think, perhaps the parts that might be most relevant today. So a tiny introduction to its history, I think, also matters, because one of the key aspects of this goes right back to its political partisan origins in our current government party political manifesto, which said they wanted to reduce the commercialization of childhood. Now, that was way back in 2010. And this idea has been formulated and reformulated going through for over a decade until we got to the sort of 2017 Green Paper and 2019 White Paper around what was then the Online Safety Bill, and then got reworded to be about online harms. And that reshaping and reformulation is interesting of itself, because then it became a focus around trying to make, the language used was to make the UK the safest place to go online. So they wanted to create this sort of world-leading regime for internet regulation, particularly around children. And the focus being around children matters, because this has shaped the kind of language and the understanding and the framing of the report, not on party political lines, but rather more on a sort of values-based shaping. And that has been really quite significant in how the bill has now come about. Where it is today, it's effectively around platform and internet regulation, and primarily now has moved away from its original principles, which was around systemic sort of questions around things like algorithmic recommendation, or looking at how the systemic issues of internet regulation might be managed, has moved towards content regulation. In fact, right down to the very detailed most recent edition that came through in the House of Commons. For those outside the UK, that's our lower parliamentary house, where the bill has already completed its first stage, adding a clause that the positive light of migrants arriving by boat in the UK should now be added into the bill as content that is seen as illegal or harmful and somehow should be removed and not be allowed to be online anymore. So it's really moved from a very high principled debate right down now to very, very nuanced, detailed, value-laden content. And this matters when it comes to talking about children, because it's put a lot of responsibilities onto companies. It's shifted really the sort of responsibility and arguments debate around who gets to say what online, and has grouped the kind of content that is seen as not only legal, but is also seen as harmful into different categories. It's also important to say this is a very shifting, very fast moving still subject, even though we're now in the House of Lords, our upper house, and it's gone into sort of discussion for more nuanced debate and amendments. It's still right at the last minute, the duty on companies to take out sort of content that was considered not illegal, but just harmful has been removed, although it's remained for children. So some of these questions are still very open. And it's one of the concerns that is actually really strong still across civil society and many who are concerned about the bill, because it leaves a lot open. There's not sometimes very clear, factual, easy, foreseeable consequences from the bill, because the wording leaves a lot open to future, what's called secondary legislation, or to Ofcom, the regulator, to make decisions around codes of practice. So it also follows a trend of what we're seeing in UK legislation at the moment, which is to take more powers to the ministers to be able to direct others to make legal decisions and to determine things which really go beyond what we would normally have as established democratic process. We have a wide public parliamentary debate. So we're seeing a shift in how the legislation is being really designed, how we're able to oversee it, and how it will be seen in future. And I think this is very significant when we're looking at what kinds of thing it's regulating, and when it's looking at how the future of the internet and our digital lives should be shaped, because this is what this bill is about. I think it's really important we don't underestimate the importance of the bill, because it is so wide-ranging, so far-reaching, and actually almost beyond most policymakers' ability to really keep a handle on, because it has become so big. So it obviously is around, become this debate around children's online safety, and to come to our own kind of remit and specialization. The bill demands the use of new technologies in order to regulate content. So it talks about things like age verification and age assurance, and it requires companies to keep children away from certain areas of content. Now, that content is already illegal for the most part. We're not talking about making new types of content illegal, but the gray area around what is considered harmful is still pretty vague. The types of technologies that will be used for age verification and age assurance will mean new gatekeepers get to control what children can and cannot access online, and really deviate from what the original principles were behind the bill about this reduction of the commercialization of childhood, because you'll see a whole new set of gatekeepers set up with new business models that will be collecting children's information in order to perform these age verification and age assurance duties. And then we've got the whole regime around content management, which will be looking at both content that cannot be online. So it makes demands around things like upload filters implicit, if not explicit, in the bill. And it also has requirements so that certain content must not be online and must be taken down. So that looks at employing removal, content moderation and content removal. Now, increasingly, of course, that's using automated technologies, and there's concerns around the reliability, the correctness, and problems that can introduce. And of course, for children, where their views may not yet be fully formed, where they may not explain things very well, there's concerns around things like, what does that mean for participation when there is already legal cases and legal precedent around content takedowns and legal problems for users who have made jokes or have got involved in content that has been seen as contentious when the intention wasn't there. So there's lots of problems around definitions, lots of problems around what these implications will be beyond that what is explicit in the bill. There's a lot of concern around things for the interception of content in both public and private messaging. And this is perhaps Jan will come on to speak to a bit more. This, of course, is where it touches on then the area of encryption and safe communications that Diana outlined so well. And surprisingly, in a bill which has been stated as being all about protecting children, there's been no child rights impact assessment of the bill at all. So we're not able to really explain well to policymakers in a carefully thought out approach, as Diana outlined, the full range of rights that are affected by the outcomes of the bill and the regulation. So some of these key implications will go beyond what is explicit in the wording of the bill. There will be a chilling effect. We're very concerned about the children's participation and autonomy and agency when it requires parental oversight and parental use of age verification, age assurance tools, and even those types of tools that don't work very well, where children are able to work around them, actually being forced into perhaps more dangerous parts of the internet because they're trying to avoid these tools, or being excluded from areas where they need to access information, particularly for teenagers developing things like sexual information about sexual development, areas which may be contrary to what their parents would be supportive of them to access in perhaps culturally conservative households. So there's lots of questions about the impacts for children, the lack of clarity, age verification, age assurance, content takedown, and participation. But really, I think the sort of the crux of what the bill really is aiming to do versus what it will actually do in practice is something that I think we all need to take much greater regard of, is the implications for the international implications when we end up with these domestic sort of what we would call a splinter net type approach of taking domestic regulation, looking at extraterritoriality is very unclear in some of this approach. What will it have for providers outside of the UK? What does it mean for participation when the internet doesn't have borders in the same way that our geography might have? And the changing position of the UK post-Brexit has meant that we're left without some of the protections that we had around communications in European law, and we're now exposed to fewer protections for private communications and that content we put online.
It's interesting because UK citizens have fewer protections. UK government imposes duties on providers that are global because of those fewer protections, and the consequences can be global because of that, because the providers are global. And once they do it for the UK, they're going to be asked to do it everywhere. It's very troubling. That's one of the reasons why we're focused at the Global Encryption Coalition on the online safety bill. And we're going to dig a little deeper into the online safety bill with June in just a second. But before we do that, I want to remind people to get their questions in. And you can get your questions in 3 ways, as I said. You can email them to questions@cdt.org. You can tweet them to #CDT questions, or you can, if you're watching on Zoom, enter them into the Q&A function at the bottom of your screen. June, you're up next. And again, I want to dig a little deeper into the online safety bill. and Liberty did a really good briefing paper on the bill. And as it says, as you say in the briefing paper, the OSB imposes a duty on private messaging services and public services to ensure that users aren't exposed to unlawful content like child sexual abuse and exploitation material. What are you, Liberty, and the other privacy groups asking Lords to do to ensure that compliance with this duty doesn't compromise encryption? And how's it going in this very difficult political environment?
Thanks so much, Greg. And just wanted to say, like, the presentations from everyone have been really interesting and really useful, I think, in trying to make this a more constructive and nuanced debate. And I think Corinne and Defend Digital Me's report was really fantastic and came at a really helpful time for this debate. Just before I go into kind of the political advocacy and lobbying that's been going so far, I thought that maybe I can kind of drill down into the detail of what Jen mentioned, which is only one of the concerning aspects of this bill from a child rights or human rights in general perspective. And I should say, like, just to illustrate kind of the breadth of the concerns, and Jen did a great job of like outlining just a few of them. This clause that I'm going to be talking about of the online safety bill is 110 of, I think it's 212. Obviously, not all of them are substantive, but I think if we think about what is required for robust scrutiny of a piece of legislation, the conditions that are required, like the kind of technical knowledge, especially when you're dealing with, legislation that might have such a, specific impact and is so dependent on the existing capabilities of private companies, technical capabilities. It really, in and of itself, demonstrates that an attempt to kind of pack it all in and do it all, and then also make changes along the way, has resulted in really stop-start process that also, I think, has really impeded meaningful scrutiny and debate and nuanced debate about these issues, which, demand like actual discussion. But unfortunately, as people on this panel and some people watching may know, that has not been the spirit of the debates, I would say, throughout the passage of the online safety bill. But better late than never, maybe we can, through this panel and other interventions, try and instill that, even now that the bill is still going through its kind of House of Lords, which is our second chamber, upper chamber phase for changes. So we call them amendments, but effectively they're just changes to the legislation. So just to drill down a bit, I will be talking about clause 110, and maybe I'll put it in the chat later so people can follow along if you're not aware of it. But effectively what it does is to give Ofcom, which is our current existing communication regulator, but that also, regulates TV, radio, but also like broadband, and under this bill will be given a raft of many other duties that Jen has spoken about, but also crucially, the ability in the case of clause 110 to issue internet service providers, so like social media sites, but others as well, with a notice to deal with child sexual exploitation and abuse content, whether communicated publicly or privately through the service. And this notice could require providers to use accredited technologies, in quotes, to identify and take down this child sexual exploitation and abuse content, or CSEA content. And this technology is defined as like content moderation technology, which will seek out, identify the content, intercept it, and then remove it. And in terms of how the technology, like the specifications of the technology, that's to be determined by the Secretary of, to be determined by the Secretary of State, sorry, and then which must be then approved by, sorry, will be suggested by Ofcom and then approved by the Secretary of State. So there is kind of a level at which the government will be able to kind of approve the level of specification or the kind of specification that this technology can will be required to reach. And then at some point within the bill's passage in the lower house, and also this was kind of interrupted by various political events in the last year in the UK, effectively there was a new provision added, which is that providers of these services might also be given a requirement to use their best endeavors to develop or source their own technology to achieve the same purposes as accredited technology. So effectively requiring, say, I don't know, WhatsApp to develop technology that will make it possible to scan WhatsApp's own messages.
How can that be though? How can that be though? Because WhatsApp is offering an end-to-end encrypted service. And so how can it be the case that they could be ordered to find content that by definition they can't find because the service is encrypted end-to-end? How are the members of parliament grappling with that question?
That's a really good question. Unfortunately, I have to answer that the answer is that they have not grappled with it, or like they have grappled with it to a very minimal extent, because of a few reasons. But I think, again, the fact that there's so much in the bill to debate, and kind of, if you've had the pleasure, I don't know, whatever you want to say, if you've listened to any of the debates, it's a little bit of an exercise in government by anecdote or legislation by anecdote, whereby every parliamentarian seems to take up their own pet issue and try and make a case for it in a legislation that is already kind of bursting at the seams. But on this issue in particular, and I think Diana's exposition and outlining of that dichotomy between privacy and protection has really dominated the discussion on this aspect in particular, to the extent that from a lobbying and advocacy perspective, we even try and avoid using the word encryption, because instead we've been trying to focus on private messaging. And also the other aspect of what I have wanted to touch on is the kind of wider implications of this. And it's really great to be on a panel with Caroline, because I think the kind of other rights concerned with this legislation, apart from obviously the intertwined nature of encryption and the right to privacy and the right to freedom of expression and all the other rights which the right to privacy enables, especially for people who may face other obstacles to that, structural oppression, or in this case, in this webinar, like children from different backgrounds who may face other obstacles to accessing their rights. There's also like a really significant effect of the bill that so far has not had as much tension, which is the way it kind of enables mass surveillance from the back door. And Liberty and Privacy International recently had a brilliant victory in our kind of investigatory powers tribunal. So that's kind of the tribunal that's set up to deal with issues of national security, whereby effectively serious wrongdoing was found by our security service about kind of the ways that they were undertaking their mass surveillance powers. And without going into the detail of this, I think it's really, if we draw an analogy, obviously they're not exactly the same and the enabling powers are different. And there are many different safeguards in that piece of legislation that we won on, or we were challenging the use of the Investigatory Powers Act. By analogy, the Online Safety Bill provides for much fewer safeguards. It responsibilizes a whole new regulator effectively, because Ofcom will be given all these new powers and have to train all of its staff in order to, well, recruit and then train all of its staff to be able to do this. And then it will be required to do this incredibly difficult, sensitive exercise of trying to balance different rights, if it does do so, in, you know, assessments of whether requiring technology companies to kind of scan people's private messages, whether that's a proportionate exercise. And if even our security services can't be relied on to do it in a way that, you know, protects people's rights, and obviously we also argued that it shouldn't be the case that they should be able to do that. But even if a security service can't do that, then how is a newly responsibilized regulatory body going to be able to do that? And I think
that's a really good point. It does seem to me like they're giving an awful lot of responsibility to Ofcom, and it's going to be put in a difficult position. And also, it has responsibility and not a lot of guardrails, and that seems like a recipe for disaster. So we have a question in the Q&A from Mr. Andrew Zach, and he's asking, where is the online safety bill in the legislative process in the UK? And is there a deadline after which it dies if it doesn't get enacted? And what are the next steps for it? Who'd like to step up for that one?
I can respond.
Thank you.
I'll keep it short. But so it's currently going through what's called committee stage in the House of Lords, which is when changes will be debated. And then we can expect that in the Lords, and we've already seen actually, as of yesterday, the Liberal Democrats, which is a party, have tabled an amendment that we're supporting to exclude private messaging from Clause 110, which is really great. And we hope that there will be cross-party support for this amendment moving forward. I think the question about the deadline is interesting because basically, usually the end of the legislative session would be kind of in March, April time. But actually, last year, the government has extended the parliamentary session so that it will continue until, I think it's October or November. And because of the kind of many iterations the bill has gone through, if it doesn't pass by then it will fall. But effectively, you know, you can draw your own conclusions. There are many different legislative plans that the government is passing at the same time. But yeah, I think it's obviously this bill will be probably one of its main priorities, given how long it's taken so far already.
So after it goes through Lords and the amendment process that you described, then what happens to the bill?
So any amendments that the Lords vote through, if the government doesn't accept them, then they have to go back to the Commons for a process called ping pong. Effectively, it ping pongs between the houses until a compromise is reached, or the government wins.
We have another question, this from Emma, and the question goes to the duty of care that the online safety bill imposes. And the question is, does the duty of care pertain to categories of content within recommender algorithms? These are algorithms that recommend different types of content to people. And if it does, what's anyone in the group's perspective on that issue in particular. Caroline, that might be up your alley. So if you could take a drink of water and then give us your perspective on that, we'd appreciate it.
So I may need a little help on this one because I'm not as aware of that particular detail of the bill actually, and I don't know if Jen or June know with regard to the recommender algorithms, or if it's just a more generic duty of care with regard to the content that is online. Do you know that is going to be allowed to be on the services? No.
I think the bill has a generic duty of care.
Yeah, I think it is generic. But to the extent that it does, I mean, just generally, and taking this question in a slightly different direction, I wanted to go back to your point, Greg, which I thought of when I saw this question about the impact that this bill is going to have globally. So to the extent that there are rules and duty of care being placed on these global service providers with regard to what content can be put on the service or what content has to be searched for, particularly when it comes to encryption, to the extent there's a general monitoring duty being imposed, it means that these companies will have to build tools that no matter how well the online safety bill tries to construct a mechanism whereby the duty of care is strong, it's very limited, it's not trying to impact freedom of expression that much, for instance. Many other countries could then ask for access to these tools, and those countries may have much less noble intentions and may intend to impose forms of content restrictions or censorship, or to persecute people by the type of content that they are seeking, particularly through client-side scanning of end-to-end encrypted communications. And so I think that is sort of a larger perspective on the online safety bill, is that no matter how strong the safeguards are, and as has already been well pointed out, they're not necessarily that strong as they are, this could have global ramifications that I think are not being well considered at the moment.
Yeah, I would add to that. I think it's one of the big criticisms of the bill is that it is focused on content rather than systemic structural issues like this. And it's failed to tackle things that would be more of the crux of how these systems are designed, such as targeted advertising and the ad kind of structure of how these things work. And that is where the bill started out, but it's not where it is now. And it's why it needs to be really, really reined back in terms of what the bigger picture effects are going to be. I think it's had a lot of questions around, for example, children's mental health and how children will be affected by recommendation algorithms of what they see now as a child has long-term effects. But it's not really been thought out how the bill's content restriction will do that. And I wanted just to come back to Greg, your original question, your earlier question on WhatsApp, because I think it's an important one. You have to think back to sort of 2020 when our Home Office minister wrote an international letter, and she opened this up to international signatories that really said, on the one hand, we support encryption, but on the other hand, we want nobody to have encryption because we think it makes the world less safe. And so there's this dichotomy between the government's position that is in this bill, but is not being properly debated. And the crux of it is really being able to access things like WhatsApp. And so if the bill goes through as it is, the duty is not explicit, but it is in there to be able to access all content at the direction of Ofcom. And so that will mean private content if it is accessible. And if it's not accessible, you're going to have directors liable for not being able to get into it at the direction of Ofcom or the Home Secretary. So it's a really complex spaghetti network at the moment of liability and accountability. But I think it's really telling that letter at the moment was updated in January this year. It's been out there for 3 years. It's only signed by 10 signatories. Half of the countries, 5 of whom support and have active use of the death penalty at the moment. And I think that speaks to the human rights aspects of the kind of principles behind this, is that it's not widely supported from a human rights principles basis. It really goes against established law, established practice, and established human rights principles that have been around for a long, long time. And this bill is kind of very quietly doing away with some of those established principles in law. And I think there needs to be much more international attention paid to what this bill is actually trying to do on the quiet. And it's not doing things that children would really need, which is looking at mechanisms for redress, support for mental health, support for counseling, looking at investment opportunities for children who are both victims and survivors, and adult support organizations when they've been exposed to content online or experiences online that have caused them harm, and really being able to look at what is our support structure and infrastructure for children in their entire experience of life, in which digital now plays a part, rather than looking at pointing the liability and responsibility at sort of after the event to companies. And we have to be very clear, it's often misunderstood, that this is not just about big tech. This is, the government's own assessment says this is about 25,000 UK companies, and scope creep will inevitably mean it is much more. So just wanted to come back to a couple of those things from earlier.
I appreciate that. I want to bring Diana back into the conversation. One of the recommendations that Crin and Defend Digital Me made in the report was that encryption shouldn't be banned in services that children use. And I'm wondering how you see that recommendation in light of the online safety bill and this basis for the bill, that one of the responsibilities, duty of care of the providers is to keep it so, is to make it so that children don't see illegal content. Or how can that goal be vindicated in the context of an end-to-end encrypted environment, with still giving children the opportunity to use a service that is encrypted end-to-end? Is there a way to do that that I'm missing?
Thank you, Greg. So I think the principle that you are referring to is this idea that there should be no generalized ban on encryption for children. So I think the word generalized there is quite important, because what we look at is really the idea of proportionality, necessity and proportionality. So we take a children's rights approach. So we look at issues from this idea of rights, which could be limited under certain principles like legality, necessity, proportionality. So the idea, the principle that we are putting in our report is about the generalized ban on encryption for children. So the idea that perhaps has been vehiculated that under 18s should never be able to use encrypted services. So we think that this would leave them vulnerable to a wide range of exploitation and abuse, and that this really requires the regulation of applications of encryption. Now, to go back to your question of how this relates to the online safety bill and how could these two ideas be compatible, I think the problem with the online, one of the concerns that we have with the online safety bill is what some of you have also mentioned, is this idea of how many things are left implicit and how many things are not debated properly. So we say that there should be no generalized ban on encryption for children. We say that it is possible to regulate the applications of encryption, but that this must be consistent with children's rights. And this is where we go into ideas of rights that can be restricted based on specific principles. So this is the kind of discussion that we really haven't had. So, for example, in terms of things like client-side scanning, it is important, I think, to recognize that this is a tool that child protection advocates are hopeful for, are excited about. And because they see it as a solution to their problems. At the same time, in the report, we highlight some of the issues that this poses. And we say that, there is no technological silver bullet. This is really a series of trade-offs. And I think this is where the conversation should be placed in this space around rights and principles and what are legitimate restrictions of rights. But the problem is that we don't see it with the online safety bill, for example.
Thank you. Thank you very much. We're at the hour, but I wanted to pause and see if there was any other comments that any of the panelists would like to make before we conclude the event. Was there anything that anybody said that you'd like to respond to or comment on?
If I may, Greg, I would ask just to come back to something we didn't really expand on earlier, which is that these technologies that are seen as solutions are not one size fits all. And too often people are talking about a technology which is not adequately suitable for what they want the solution to be. And everybody wants to have safe experiences for children online and protect children online, but it can't be at the expense of every other right that they have. And we've seen, for example, even CDT has brought out a report last year, Hidden Harms, talking about digital safety technology for children. These technologies are really, children have been the canary in the coal mine for a lot of these content moderation, filtering, and blocking tools. And they almost do exactly the kinds of the topics that they filter and block children from access are almost mirrored exactly in what was in the online safety white paper in 2019 by content, what was considered legal but harmful. So the direction of travel is to go towards these types of filtering and content moderation, which children have been exposed to in the UK in schools for several years. And there is no transparency around their error rates, how many times false positives are flagged, how many times children try and access something that is blocked, and then they are profiled for having an interest in extremism or terrorism, for example, under our UK prevent duty. There's no indications of how many children have been flagged as potential, as at suicide risk when they've been looking at things like, walks on cliffs. These are real case studies we've had teachers come to us about, and concerns that the technology companies then have no oversight because the companies determine what is used to flag in their algorithms in these automatic AI technologies, what is blocked and what is searched for and what is profiled about children. And so without any oversight of the company's activities, then these companies become the gatekeepers and also the sort of profilers of children in ways that we just don't see. And these data are then being exported to all sorts of countries where the companies are based. So I think if we're going towards a world in which we automatically identify content as bad content that people should not access, we have to be very, very acutely aware that the scope creep is what has already happened to children in UK safety tech, which is then that individuals are profiled for having wanted to access that content. And what that means is then building up not only, taking down content and taking that content offline, but taking people in special interest and maybe, what happens next to individuals. So I think that is real in the case studies we've already seen today. For example, Hidden Harms, the CDT report identified 13% of, they think 13% of people asked in that survey had knew of somebody who was LGBTQ had been outed by the use of that technology. So other people knowing what you've been searching for or what you're interested in, your behavior online has real world implications offline. I think that's not been properly assessed for children at all in these use of these proactive monitoring technologies and behavioral monitoring technologies. So I'd really urge people to take much more of an interest in what that kind of loose wording really means in reality, and speak out to policymakers, speak out to people in your community or in teaching, and really get involved in what do these new automated technologies mean? What does it mean when we give power to companies to identify these types of technologies and use these technologies? And we have to hope that the online safety bill really takes some more account of these implications and impact for children, for all of their rights.
Thank you so much, Jen. And thank you also for plugging the CDT report on hidden harms. You can find that report by searching on the name of our organization, CDT, and hidden harms. That's all the time that we have. I want to thank each of our panelists for coming on and sharing their views on children's rights, encryption, and the online safety bill. And again, you can find this, we'll have a recording of this webinar on our website, www.cdt.org, and at the Global Encryption Coalition website, www.globalencryption.org. Thanks, everyone. Have a good rest of your day.